Welcome back to the Listen and Learn series. Today we're discussing trusts, and specifically trust formation and administration. We will start with the basic definition of a trust. Then we will talk about the requirements for creating an express trust. We will finish by talking about trust administration and walking through a few hypotheticals to test your understanding of trust formation and administration. So let's start with some basic terminology. A trust is a legal arrangement where a property owner transfers property to a trustee and gives the trustee the duty to manage the property for the benefit of one or more beneficiaries. The property owner transferor is called the settlor. This is the party who creates the trust. The settlor's creation of a trust divides the ownership of the property into legal and equitable interests. The trustee receives legal title, and the beneficiary or beneficiaries receive equitable title. The creation of the trust also imposes fiduciary duties on the trustee to deal with the property in a way that benefits the beneficiaries. A trust created based on the express intent of the settlor is called an express trust. There are situations in which the law or courts will create a trust as an equitable remedy. However, today we are focusing on the creation of an express trust, a trust that the settlor intends to create. When a settlor intends to create a trust, the settlor has the option to create the trust either during the settlor's lifetime or after the settlor dies. If the settlor wants to create a trust during the settlor's lifetime, this is called an inter vivos or living trust. If the settlor wants to create a trust to take effect upon the settlor's death, the settlor must include a gift in trust in the settlor's will. Once the settlor clarifies when the trust should take effect, the settlor must complete the requirements for creating a trust. But before we go through the list requirements, we must briefly discuss two additional distinctions. First, trusts may be either revocable or irrevocable. In most states, a trust is considered revocable unless the trust states otherwise. The second distinction we must make is between private trusts and charitable trusts. Private trusts are created for non-charitable beneficiaries, such as the settlor's children or friends. Charitable trusts are created for charitable purposes, meaning a purpose that conveys a substantial benefit on society. First, we will discuss the requirements for creating an express private trust. Then we will talk about the distinctions for creating a charitable trust. In general, a valid express trust requires the following: 1. A definite beneficiary or beneficiaries. 2. A settlor with capacity to create the trust. 3. Evidence of the settlor's intent to create the trust. 4. A named trustee. 5. A valid trust purpose. 6. Trust property. And 7. Compliance with any state formalities. So let's look at these requirements in more detail. Regarding the first requirement, a definite beneficiary or beneficiaries. The beneficiary or beneficiaries may be natural persons, corporations, or organizations. If there are multiple beneficiaries, the beneficiaries may hold concurrent interests, meaning that each beneficiary has a present interest in the trust property. Alternatively, the settlor may create a trust in which beneficiaries have successive interests. This is where the present and future interests that you studied in property law overlap with trusts. For example, one beneficiary may be entitled to trust income for life, with remaining trust property passing to a remainder beneficiary. This situation is similar to the life estate remainder interest you studied in property. Also, like in property law, most states apply at least a modified version of the rule against perpetuities to trust beneficiaries. We will discuss the RAP's application to trusts in more detail in a future episode of this podcast. But for now, keep in mind that it does apply in some capacity to the vesting of a future interest in trust. A couple final notes on the definite beneficiary or beneficiaries requirement. The settlor may be the beneficiary of the trust, and a trustee may also be a beneficiary as long as the trustee is not the sole beneficiary. Remember, a trust must divide property's legal and equitable title. If the only beneficiary were also the trustee, that requirement would not be satisfied and there would not be a valid trust. Regarding the second requirement, it is usually fairly easy to tell from the fact pattern whether this element is at issue, that the settlor has capacity to create a trust. In most states, the settlor must have the standard capacity to enter any contract or create a will. If you do not see any facts indicating that the settlor could not enter a contract or create a will, this requirement is satisfied. For the third requirement, the settlor must intend to split legal and equitable title and impose fiduciary duties on the holder of legal title. This does not require that the settlor has knowledge of the precise trust terminology. For example, consider settlor's intent if settlor transferred money to his friend Trent, stating, "Invest this money for my son Ben and give Ben income every year until he reaches his 30th birthday. Then give Ben the remaining principal from the trust." Here the language is sufficient to show that settlor intended to divide the legal and equitable title and create a trust, even though the settlor did not use formal trust terminology. Regarding the fourth requirement, a named trustee, as we talked about, the same person cannot be the sole trustee and the sole beneficiary. In that case, the legal and equitable title in the property would not be split, and therefore there is no trust. However, as long as the sole trustee and the sole beneficiary are not the same person, a trust will not fail if a named trustee fails to act, dies, or resigns from their duties as trustee. As long as the settlor names a trustee initially, the court will appoint a new trustee if that trustee is unwilling or unable to serve in that role. For the fifth requirement, a valid trust purpose, any legal purpose is a valid purpose to create a trust. Regarding the sixth requirement, trust property, it is important to note that the trust is not created until it receives property. However, the trust's receipt of the property does not have to happen at the same time as the signing of the documents to create a trust. For the seventh requirement, compliance with state formalities, this may require the trust is signed by a notary, depending on state law. Now, there is one other rule that we must consider when talking about trust formation: the statute of frauds. You'll likely remember from contracts class that the statute of frauds makes certain types of contract unenforceable, unless there is a writing that satisfies the statute of frauds requirements. You may also remember that the statute of frauds applies to all contracts for the sale of land or real property. Similarly, most states apply the statute of frauds to all trusts of real property. Now that we have discussed the requirements for creating a private trust, let's talk about charitable trusts. First, as noted above, a charitable trust is a trust created for a charitable purpose, meaning that the trust is established for the benefit of a community or a large segment of a community. There are 5 widely recognized categories of charitable trusts. 1. Trusts aimed at relieving poverty. 2. Trusts that advance education. 3. Trusts that advance religion. 4. Trusts that promote public health. And 5. Trusts that support governmental purposes, such as a trust to fund a park or museum. Most of the same requirements discussed earlier apply to creating a charitable trust. However, there are a couple important distinctions. First, as discussed, creation of a private trust requires naming one or more definite beneficiaries. Alternatively, charitable trusts require naming a sufficiently large or indefinite class of beneficiaries so that the beneficiary is considered the general public, not a particular person or small group. Relatedly, the rule against perpetuities does not apply to charitable trusts, so a charitable trust may theoretically continue indefinitely. And of course, there is an obvious distinction that a charitable trust must be for a charitable purpose, such as one of the 5 categories previously discussed. Alternatively, a private trust may be created for any legal purpose. Now that we have talked about the creation of private and charitable trusts, let's briefly talk about trust administration. The trustee has several duties when administering the trust. In particular, the trustee owes a duty of care and the duty of loyalty to the beneficiaries. The duty of care requires that the trustee administer the trust, 1. in good faith, 2. in accordance with the trust purpose and terms, and 3. in the interests of the trust beneficiaries. The trustee must also act as a prudent person would and take reasonable steps to protect the trust property. Regarding the duty of loyalty, the trustee must refrain from self-dealing, conflicts of interest, and act impartially. Acting impartially means that the trustee cannot be influenced by their personal favoritism or animosity to any beneficiary. Well, now that we have covered the basic rules for trust formation and administration, let's walk through some hypos to practice applying these rules. Here is a hypo adapted from the February 2012 bar exam. Sam invested $10,000 and transferred the investment to his cousin Tara, stating that Tara should manage this investment for his children, Anne, Beth, and Carol. He directed Tara to distribute the income from the trust annually in equal shares to Anne, Beth, and Carol. Sam lives in state X, which has no formal requirements for creating a trust. For 3 years, Tara managed the investments for the benefit of Anne, Beth, and Carol. Because Anne had very serious medical problems and could not work, and because Beth and Carol had sufficient assets of their own, Tara distributed nearly all of the trust income to Anne and a little to Beth and Carol. Beth and Carol have filed suit against Tara, claiming breach of fiduciary duties. 1. Did Sam create a valid trust? Discuss. 2. Are Beth and Carol likely to be successful in suing Tara? Discuss. Regarding question 1, let's walk through the requirements of a valid trust to ensure that they are all satisfied. First, we have 3 definite beneficiaries, Anne, Beth, and Carol, and we do not have any wrap issues with these beneficiaries because all 3 are living and have a present interest in the trust property. Second, nothing in the fact pattern suggests that Sam did not have capacity to create this trust. Therefore, the second requirement is likely satisfied. Third, Sam's intent to create a trust is indicated by the language in his transfer to Tara. This language indicates that Sam intends to divide the legal and equitable interest in the trust property, the investment, and impose fiduciary duties on Tara to manage the property for the beneficiaries. Regarding the fourth requirement, there is a trustee, Tara, and there is a valid trust purpose to provide for Sam's children. There is also trust property, the $10,000 that Sam invested. We have also been told that there are no additional state formalities. Therefore, this is a valid private trust. Now let's talk about whether Beth and Carol are likely to be successful in suing Tara. As we talked about, as a trustee, Tara owes certain fiduciary duties to the beneficiaries, Anne, Beth, and Carol. In particular, the duty of care required Tara to administer the trust in good faith and in accordance with the terms of the trust. Additionally, the duty of loyalty required Tara to act impartially when administering the trust. Tara likely violated both fiduciary duties here. First, Tara did not administer the trust in accordance with its terms. The trust indicates that Tara must distribute the income in equal shares to Anne, Beth, and Carol. Contrary to the trust terms, Tara distributed more income to Anne than to Beth and Carol. Therefore, Tara did not administer the trust in good faith or in accordance with its terms, nor did Tara act impartially. Impartial administration would require Tara to follow the terms and distribute the income equally. By unilaterally deciding to distribute more income to Anne, Tara improperly acted based on her personal judgment regarding the beneficiary's relative needs. It does not matter that Tara's actions may have been well-intended. Beth and Carol are likely to be successful in suing Tara because she violated her duty of care and duty of loyalty by distributing more income to Anne, and Tara is personally liable for damages to Beth and Carol for the breach of her fiduciary duties. Now let's look at a second hypothetical regarding the formation and administration of trusts. In 2003, Sam executed a document intending to create a trust to fund his newborn nieces and nephews' education. The document states, "I give the money in investment account 3341 to my brother Jim to manage for my new niece and nephews, Becky and Ben's college educations. Jim, in his discretion, shall use this money to equally contribute to their college educations. After Becky and Ben graduate college, the trust income shall be donated each year to fund higher-level education for those who cannot afford it. Sam complied with all state formalities for creating a trust. At the time Sam drafted the document, he had opened investment account 3341, but he had not funded it with any money. Sam intended to start funding the account immediately after signing the document, but he was unexpectedly laid off the same week that he signed the document. As a result, Sam did not fund investment account 3341 until May 2005. In 2021, just as Becky and Ben were both headed to college at State University, Ben and his father, Jim, had a falling out due to their political differences. Jim refused to pay any money from the trust to pay for Ben's college. Instead, he used all of the trust income to pay for Becky's education. After Becky graduated, Jim annually donated the trust income to his alma mater to fund scholarships for those who could not afford tuition. So 1. Did Sam create a valid trust? And if so, when was the trust created? 2. Assuming Sam created a valid trust, is the trust a private or a charitable trust? And 3. What rights, if any, does Ben have against Jim? So let's start with question 1 and walking through our requirements for a valid trust. First, there are 2 definite beneficiaries, Becky and Ben. There is also an infinite subsequent beneficiary, anyone who may later benefit due to funding to higher education for those who cannot afford it. We will talk more about these subsequent beneficiaries in answering question 2. But for now, we can say that the first requirement is satisfied. Second, there is nothing suggesting that Sam did not have capacity to create the trust. And third, the prompt tells us that Sam intended to create a trust to fund Becky's and Ben's college education. Fourth, we have a named trustee, Jim, Sam's brother and the twins' father. Fifth, funding college for a niece and nephew is a legal and valid trust purpose. And we were told in the prompt that Sam complied with all state formalities, so the only requirement that is arguably at issue here is requirement 6, trust property. When Sam signed the trust document in 2003, he had opened the investment account. However, he had not funded the account with any money. An unfunded account is not property for purposes of this requirement, and Sam's intent to later fund the account is not sufficient to create a trust at the time he signed the document. But remember, the property requirement need not be simultaneous with all of the other requirements. Therefore, when Sam funded the investment account in May 2005, a trust was created. Thus, Sam created a valid trust in May 2005 when the investment account was funded because that satisfied the final trust creation requirement, trust property. So let's move on to question 2. Is this a private or charitable trust? We know that advancing education is a widely accepted charitable purpose. So as most of you likely spotted, using the remaining trust income to pay for college educations for those who could not otherwise afford to attend college is a valid charitable purpose. But what about paying for Becky's and Ben's college education? Generally, this would not be considered a charitable purpose because the beneficiaries are definite and related to the settlor. In general, to find a charitable purpose, the trust must benefit either a large group of beneficiaries or, in some jurisdictions, an indefinite beneficiary, such as someone who receives a scholarship. Here, funding for Becky and Ben's college education will not be sufficient to constitute a charitable trust because it cannot be said to benefit the community or a large part of the community. Therefore, the trust for Becky and Ben is a private trust even though it furthers their higher education. Now, as most of you likely spotted, this trust becomes a charitable trust when Becky and Ben graduate, and the income is then distributed to uncertain beneficiaries who will benefit from the trust. And it is clearly for a charitable purpose, advancing education. Notice that it is okay how vaguely these future beneficiaries are described. Also, the trust could theoretically continue forever because Sam wants the income to be distributed to fund higher level education for those who could not afford it indefinitely. Since this is a charitable trust, the wrap does not apply and this infinite benefit to uncertain beneficiaries is valid. Now let's talk about what rights Ben may have against Jim. As noted in the prior hypo, the trustee owes certain fiduciary duties to the beneficiaries of the trust. and Jim was instructed in the trust to use the money equally to contribute to Becky and Ben's educations. However, the trust specifically says that Jim must do that in his discretion. That means that Jim will argue that he was given discretion regarding whether to fund Becky and Ben's college tuition equally. This is where the duty of loyalty to act impartially and not based on personal favoritism or animosity towards a particular beneficiary is relevant. Here, Jim acted based on his personal animosity towards Ben's political views. Therefore, even though he was given discretion, this is a breach of his fiduciary duty of loyalty to Ben. Thus, Ben is likely to succeed against Jim in a lawsuit for a breach of fiduciary duties. And with that, we have wrapped up our discussion of trust formation and administration. If you enjoyed this video, please take a second to give us a like and leave us a comment, and be sure to subscribe to our channel so you don't miss any future content. If you have any questions, feel free to reach out to us via the contact form on lawschooltoolbox.com.